Appreciate the opportunity to talk to doctors. You and patients are the people who are going to bring us to freedom and better health, and I appreciate your attendance here. I'm going to talk to you about how to legally recommend cannabis to your patients, which is certainly more about protecting your license than protecting your patients. Marijuana has cannabis has quite a range of safety, and the licensing issues are more political than about the care of your clients. I'm going to talk about, the scope of my talk is going to be about talking about medical cannabis practice in two contexts. And first, in terms of the federal regulation of the controlled substances licenses that many of you have, and secondly, in terms of state physician and healthcare provider licensing boards, the state level. So that would be in Massachusetts, the Board of Registration in Medicine and the Board of Registration in Nursing. And just a footnote on that, nurse practitioners have had certifying authority since 2014 as a matter of state law and as a matter of the nursing board regulations. But the Department of Public Health, which is tasked with overseeing the medical cannabis law in Massachusetts, has failed to accommodate that in their regulations. There are regulations pending to do that, and my latest information is that perhaps in June they will become final, so that nurse practitioners can be included as well. So let me talk about the feds, hopefully quickly. We all know that cannabis is a Schedule I designation with no medical use, so therefore there's no prescription authority for that. And this is in spite of the fact that the Department of Health and Human Services of the federal government has had a patent since 2003 for medical cannabis's antioxidant effect. This is also in spite of several lawsuits that have documented the medical benefits of cannabis and that the federal courts have allowed to have refused to get involved in the rescheduling process. So state medical marijuana laws have been the workaround. West Virginia is about to become the 29th state, but the first state was California in 1996. And but to get back, to enable doctors and patients to get access to cannabis, state medical cannabis laws authorize physicians and healthcare providers to certify or recommend patient access, and this is bypassing the prescription prohibition. So a certifying doctor, unlike a prescribing doctor, simply finds that cannabis, finds that the patient has an eligible condition, finds that cannabis can relieve that condition, determines that the benefits outweigh the risks, and discloses to the patient the risk-benefit analysis and access to but this is a matter of access and not dosing. My colleague Val Romano is going to talk a little bit more about the Massachusetts regulations. But again, getting back to the federal context for your work, I would say that you have a belt and suspender protection from federal interference with what you do. The belt is what I would call the Conant versus Walters decision, a 2000 trial court decision that was affirmed in 2002 by an appellate court, and for which the U.S. Supreme Court denied certiorari, so it remains the law. And under that decision, there is a permanent injunction against federal law enforcement officers and the Department of Justice and administrative agencies. They are enjoined, and I hate to read this, from either revoking a physician's license to prescribe controlled substances or conducting an investigation of a physician solely for a physician's professional recommendation for the use of marijuana. That's a permanent injunction that protects your licenses. The suspenders for federal protection from interference with your practice is the 2006 right to die case, the Gonzalez versus Oregon decision of the U.S. Supreme Court. That was the second Bush administration's reaction to Oregon's right to die law. And again, it's easier for me to read from the decision so you can understand the scope of the protection that that you have from federal interference. This is from the Gonzalez decision. Congressional regulation of medical practice insofar as it bars doctors from using their prescription writing powers as a means to engage in illicit drug dealing, that is the extent of federal regulation. Beyond that bar, however, the Controlled Substances Act manifests no intent to regulate the practice of medicine generally. The CSA's, the Controlled Substances Act's prescription requirement does not authorize the Attorney General to bar physicians from dispensing controlled substances for assisted suicide in the face of a state medical regime that permits such conduct. So there's your belt and suspenders. No matter what anybody else tells you, as long as you're practicing within the confines of a state law permitting that type of medical practice, that type of medical treatment, you are essentially immune from federal interference. So let me talk now about state law. In Massachusetts, as I mentioned, you've got the Board of Registration of Medicine and Nursing. You've got from the State Medical Licensing Board, no specific cannabis medicine practice guidances. You simply have the state medical marijuana law, and again, Val is going to speak to you more on that, and you have the Department of Public Health regulations implementing that law, and while those regulations pretty much parrot the state law, there is a continuing medical education requirement that's in there as well, and I will refer you to the access to these online and to Val's presentation. At the state level, with regard to criminal protections, doctors are immune from criminal prosecution as a matter of a state statute for authorizing controlled substances use for a legitimate medical purpose in the course of professional practice. So there's no criminal risk there. You have protection under Massachusetts tort law, negligence law, that no healthcare provider will be liable to a third party for a patient's negligence or abuse of the medicine if the risks of impairment are disclosed by the healthcare provider and documented with additional documentation of the patient's competency to understand that warning. So if the warning's documented and the patient's competency, have the patient repeat back to you what they understand to be the warnings, then that's all documented in the chart. That's your defense to a negligence action. And there's really very little malpractice risk because these recommendations and certifications are not dosing instructions. There's simply access with the patient able to self-titrate. So your tort risk is similarly minimal. The best way to protect your license is documentation. I suggest a written examination, assessment, and patient disclosure protocol, something that notes that provides you a outline of a series of check boxes to go through as you do your examinations and your assessments. And this protocol can be used to do the tasks that will protect you and then document the results of each one of those tasks in your record. The first part of safe cannabis practice, cannabis medicine practice, is a full patient medical record review. And in that, this is particularly focused on the condition or symptom that's to be treated with the cannabis. And particularly important is a condition diagnosis in the medical record by a specialist for that symptom, for that condition. Particularly so if it's beyond your specialty. You can piggyback on another specialist's diagnosis, but if a patient is coming into you for the first time with a condition that a specialist hasn't identified and you aren't a specialist in that condition, don't certify. Refer the patient to a specialist, and then you can piggyback on the specialist's diagnosis. And in-person, the next important part of the documentation is an in-person clinical examination, especially regarding the condition or symptom to be treated. You should also be looking for the patient's pre-certification use of marijuana as providing evidence for you that there may be some efficacy in cannabis for that patient. The next thing to do in the chart is to perform a literature review of the benefits and risks of medical cannabis for the symptom to be treated and for the patient's other pre-existing conditions. It's simply practicing safe medicine and filling your file with material in case there's a review. The next part is doing the certification. The certification is an assessment of risks and benefits. So the chart should include a discussion, a listing of those, your analysis as to why you believe that the benefits outweigh the risks, and a disclosure to the patient of that risk-benefit analysis. Lastly, there should be something in the nature of a treatment plan, as you would with any other patient that comes with you, that would include some metrics for assessing the value of the cannabis treatment, whether it be symptom relief, quality of life improvement, or even harm reduction. One of the ways to assist you on that and involve the patient in that process is to recommend strongly to a patient that the patient keep a diary of benefits and side effects. That is part of keeping your continuing relationship with the patient and giving you the ability to monitor how things are going with the patient. And that also should include trying to schedule. You can't compel the patients to come back, but in terms of the ongoing role in the patient's treatment, which is part of the requirement under Massachusetts law, scheduling at minimum a 2-week follow-up to see how the experience with the cannabis medicine is going, and so you can put that feedback into the chart, as well as a follow-up appointment 3 to 6 months out. You can't compel the patients to come in, but you can put those recommendations in your paperwork and have that on hand in case someone comes, as one of the licensing board comes to look at you. The most important way to protect yourself, besides this documentation, is essentially also not to have contact with the medicine, not to touch the cannabis. As a doctor, when the patient asks you about supply in Massachusetts, you can simply refer them to the licensing, to the DPH licensed distribution network. There are only 10 in Massachusetts so far. There are many more in the pipeline. Lastly, the point about why licensing boards are looking at people is simply a matter of politics and a matter of the suppression of doctor participation in medical cannabis practice. One of the chief culprits for this is the Mass Medical Society, which has been against cannabis medicine ever since the campaign for it. So that there are only a few doctors who are participating in it. They're providing, 20% of the doctors are providing 80% of the recommendations. Those people get targeted. For those of you who choose in Massachusetts to join this brigade of courageous doctors, what I've told you is hopefully going to help you if they come after you. If you've got the documentation, you are immune. I can tell you that doctors, at least one doctor who has been challenged by the board, has had the board's recommendation for suspension dismissed by an administrative law judge. The crime there was not anything to do with patient complaints and everything to do with the doctor's use of nurse practitioners. And as I mentioned, the nurse practitioner regulation has been published. It's already permitted under the nursing regs. It'll be permitted under the DPH regs hopefully around June sometime. So that's what I have for the content of my talk, but we're trying to keep our talks short so that we can give plenty of time for questions. Thank you very much.
Your mic should work over there if you want. I think, does your mic work over there? That might.
Hello, can everyone hear me? Oh, great.
There you go, better.
My name is Valerio Romano. I'm an attorney with VGR Law Firm. We represent about a third of the dispensary applicants and registration holders throughout the Commonwealth. Work closely with this process. I'm also an attorney in California, although I live here. Been doing something to do with medical marijuana for probably 20 years now. And it was great when Massachusetts passed our law in 2012. I want to say, first of all, that thank you for participating in this. If it wasn't for courageous doctors in evaluation centers really stepping up, we wouldn't have a medical marijuana program. We wouldn't have any incentive for dispensaries to try to open up. We wouldn't have enough patient access to actually collect any data. We wouldn't be moving things forward at all. Partners, for instance, is actually doing a study of medical marijuana patients over the next few months, collecting data. That wouldn't work. There wouldn't be enough patients. Right now, you can look on the Department of Public Health website, and every month they actually put up a dashboard to show you what the status of the medical marijuana program in Massachusetts is for that month. As of March 31st, there were 40,411 patients. Most of those certifications were written by just a handful of doctors, even though there are, in fact, 189 doctors who have registered to certify patients in the Commonwealth, with about six more added in March. It's very few of them that are actually doing the work. Mike Cutler touched on Dr. Naldame, who got in a little hot water for working with nurse practitioners, and fortunately has been vindicated. And in fact, nurse practitioners were authorized under the law and the regs from their inception. It was merely because there wasn't a process for allowing nurses to do this that it became a problem. And so the supervision that was going on at Canna-center was called into question, although ultimately turned out to be vindicated and they were doing the right thing. So the sources of information for you to sort of get to kind of the nuts and bolts, and I'd invite anyone to chime in as well. The sources of information, you have the regs for the medical use of marijuana program, 105 CMR 725. You have 243 CMR 1, 2, and 3 that are specifically enumerated in the regs. You have Conant v. Walters, which Mike spoke about, which really created a First Amendment privilege for you to discuss treatment options with your patient. It's the beauty of that case. You have the Controlled Substances Act, Title 21 of the United States Code. You have the Act for the Humanitarian Medical Use of Marijuana. That's essentially the law that the voters passed in 2012. 63% of people in the Commonwealth agreed on something, which is pretty cool. Rarely happens. And then you have extensive Board of Registration policies, and then the DPH guidance for physicians. And they actually lay it out pretty well. They lay out, there's some documents on the DPH website where they lay out what you can do, what you can't do, and they actually lay out the process for becoming a certifying physician. Essentially, certifying physician must be a mass licensed physician. They have to hold an active full license with no prescribing restrictions. They have to have a Massachusetts controlled substance registration. They have to have at least one established place of practice in Massachusetts. They have to complete a minimum of 2 hours of Category 1 continuing professional development credits. That CME has to explain the proper use of marijuana, including side effects, dosage, and contraindications, including with psychotropic drugs. And they have to register with the medical use of marijuana program via their website. So that's what you have to do. You also have to have this bona fide doctor-patient relationship, and the Mass Medical Society chimed in a lot. So the voters passed a 5-page law in 2012. In 2013, the Department of Public Health went around the Commonwealth and had listening sessions for how we were going to implement this 5-page law. And a lot of people chimed in, and there was a lot of insightful information that was put forth. And one of the groups that chimed in was the Mass Medical Society, who I'm sure you all know better than I do, 25,000 doctors and med students. And they really wanted to make sure that people had this, what a bona fide doctor-patient relationship would be. So unlike California, where you can get a certification or a recommendation over Skype, like a doctor's never even reviewed your medical history, doesn't know you at all, doesn't have an ongoing role, you just give them their couple $100 and you're getting your privilege to use cannabis. Here, the Mass Medical Society wants you to have conducted the clinical visit, like Mike said, completed and documented the full assessment of the patient's medical history, explained the benefits and harms, and has a role in the ongoing care and treatment. So they're really trying to make it so you have to have that role, that relationship with the doctor. And then they're supposed to use the prescription monitoring program, or MassPat now, before issuing that written certification. And so, it sounds like a lot of overhead, and a lot of doctors aren't engaging in it. So it's because of these evaluation centers, like I said early on, and I'm thankful that they're actually allowing patients who otherwise their primary care doctor, I'm sort of a cynic, and I get sort of, enthusiastic about these things, but cannabis, although we call cannabis big business, right? It's not. Cannabis business does not have, a pretty 30-something-year-old pharmaceutical rep coming into your office offering free samples and to take you out to lunch. We probably should, but we don't. And so, so that's why, cannabis is not actually probably accepted as well as it could be. Another reason is Raich v. Gonzalez, which is a case out of the Ninth Circuit, or actually the United States Supreme Court ultimately, which held that the purely intrastate production and use of cannabis actually violates interstate commerce, right? So why does Congress have the authority to regulate cannabis use if it's a purely intrastate activity? Because of this principle, and your doctors, not lawyers, but this is Wickard principle, which started somebody who's growing wheat at home. And they said it's illegal for you to grow wheat at home because ultimately you're hurting the interstate commerce for wheat. So if I'm a medical marijuana patient and Big Pharma has completely failed me, and I'm growing cannabis at home, and I got a few plants, and it's helping me, what interstate commerce am I actually harming? Well, so it's again why we need pharmaceutical reps so that we can see the interstate commerce that we're harming is the prescription of other pills and other drugs. And in fact, there was a great study. Last year, and it's actually been replicated and further analyzed. But what it said in medical marijuana states, 1,826 fewer pain pills prescribed per year per doctor. 1,826 per doctor. I know, it's awesome. 562 fewer doses of anxiety pills. 541 fewer doses of nausea medication. It goes on and on and on. And so when we look at, we're in Massachusetts, we know we have this horrible problem with opiates. When we look at what's going on in Mass, if a patient is never going down the road of Vikes and Perks and Oxys and becoming a heroin addict and then having their insurance run out, and I know I'm stating the obvious to you, but it's something that is worth being repeated. If you never go down that road, then that's why we have 1,800 fewer pain pills prescribed in medical marijuana jurisdictions. That's why the Journal of the American Medical Association came out a few years ago and said 24.8% less opiate mortalities in marijuana jurisdictions. A full 25 out of 100 fewer people dying in marijuana jurisdictions. And so the data is overwhelming. And don't let anybody tell you otherwise, because to find real impartial data, like peer-reviewed studies out of major universities, the opponents don't have that kind of data. They have purely objective, not objective, data with a particular focus. So the data's there. So to keep going, what else you need to know as far as under the law, and that's sort of my soapboxing, and I apologize. So a qualifying patient has to be a Mass resident. They have to be 18 years or older. Or if they're under 18, you have to have two physicians see them and say they have a life-limiting illness. Okay, I'll finish up and I'll pass it on, then we can move to questions. So quickly, evaluation centers, I just want to emphasize again the important role that they're playing, but also the reason why there's only a few doctors certifying most of the patients. We would love to have all of you get on board this important treatment option. Let's get together, let's collect data so that we don't have that argument against cannabis anymore, and let's figure out a way that we can really make it clear to the public as a whole, even the ones who are listening to the pretty pharmaceutical rep, that this is a good thing for the populace. So thanks for listening.
So we have only a few minutes, so Bonnie's going to give us some experience from California as well, and her experiences working with patients.
So just a few do's and don'ts, and also some cases where doctors in California have been in trouble, and they're pretty egregious, and I don't think anybody here is going to do this, but remember, in California, it was the Wild West for quite some time, and a person could just walk in off the street, say, my back hurt, you collected their money, and you gave them a letter. Most of the doctors who are still standing that are doing that kind of practice are going to be out of business because it's going to be legally available as of January 1st, and then the rest of us who actually practice medicine just using cannabis in our toolbox are going to be the ones who still see patients. I treat every patient and go through the process the same way. History, physical, review of medical records, and I do highly recommend that if you don't know the person and they are coming to you specifically for cannabis, because you're open to that and you're going to help a lot of people if you're open to that, ask them to fax or scan their medical records ahead of time. It makes it a lot easier if you know what they have before they come. and then document the heck out of your chart. I document medications that the patient has tried that have not worked. I document surgical procedures. I document how many physicians they've seen sometimes, what major academic centers they've gone to for care, for help. That is documentation that will help you, if something happens, be able to back up your decision making. On every chart I write patient, if I decide that they qualify, patient qualifies for medical cannabis based on California law. I usually write the benefits, assessing if the benefits outweigh the risk. And I also write that I've discussed side effects. In my paperwork that I give to a patient, a new intake form is 7 pages. It's 2 pages of medical information, medications they've tried, but then it's 5 pages of informed consent and an arbitration agreement. And so I've been doing this for almost a decade. I have not been in trouble with the medical board, and I've not gotten sued. I know Dr. Hergenrather is here in the audience. I see him. He's been doing a lot longer than I have, and I know he does it the right way too and has not gotten in trouble. And really, documentation is your key. I, at one point, was a medical director of overseeing 15 different medical cannabis offices about like 6 or 7 years ago, and we had some doctors who did have problems, but documentation was what saved them. And so that is the key. And where did those problems come from? So in one case, it was a parent calling saying, my son does not have what you said he has. I found his letter. And so you may get a call from a family member. We obviously, we're not going to break HIPAA. We don't know who that person is on the phone. So we say, we can't help you. We can't disclose anything. But at one point, there was a complaint to the medical board, and that doctor did have the chart subpoenaed, but because that doctor's medical records were sound, and the patient did bring in medical records, his mother didn't know the whole story and did not know other medications he was on. So that was easy, and it was dismissed. A couple cases that were just egregious and ridiculous is we had a famous case, I don't know the doctor, who a patient came in and he said, can you just give me a blank caregiver letter? And the guy, it was an undercover person from the medical board, and they got a blank caregiver letter where they could just put in somebody's name, and they made this ridiculous assumption. They said, oh, we're going to write the dog's name in there or something. It was just ridiculous, and the doctor got dinged for that. He was on probation for that, so that was one case. And then very recently, I was asked to write a letter for a doctor, which I declined to do because it was a local physician near me who who is an internal medicine specialist who saw a 5-year-old who had no diagnosis, but the family was saying, we don't want a diagnosis of ADD on the chart, but the school's saying he has ADD. Can you just give us a letter? And he did. And it ended up that the school asked, well, what medicine is he on? And they said he's on cookies. And then it went to Child Protective Services and became a big deal. The parents are thrilled with the treatment. It's just that the doctor was not qualified to diagnose a 5-year-old with ADD. So going back to what Mike said here, if you're not qualified to make the diagnosis, don't make sure they see a specialist, make sure they have paperwork. And again, in my practice, anybody under 25, they don't even get an appointment with me unless they send in medical records ahead of time. And if that takes them 4 months, then so be it. Then that's on them. There's only so much you can do.
Okay, unfortunately, I think we're going to take questions after this just due to the incoming next panel that's up. So we're a little short on the time here. This is just a lunch collision, unfortunately. But I do want to thank everybody. That's all the advice you guys have given. I think it's incredibly important that we get this correct. Having the legal understanding of the realms of what we can do is paramount to making patients have safer access. Thank you.